Namaste everybody. I Kumari Akancharai. Today we will be dealing with a very vibrant and hot topic which is related to the social issue, and its relation with the law is very direct, and it's none another than marital rape. Various High Court recently has given their judgment related to the marital rape, which includes Chhattisgarh High Court, Mumbai High Court, and in fact Supreme Court has also given its verdict related to this matter in earlier judgments. Recently on 26th of August 2021, Chhattisgarh High Court has said that sexual intercourse or any sexual activity by husband with her legally wedded wife is not a rape. In fact, it has been done forcefully against her consent also. So, in this era, we have to understand that some strata of society has accepted it as it is, but someone has just criticized it because they have not accepted it yet. We have to analyze it whether these verdicts are based on any law, or whether these are the judge's own thought, or whether they are influenced by somewhere else. We have to find out. My dear friends, we are Indian. We are living in India. We are not Albanian. We are not Brazilian, Canadian. No, we are completely Indian, where still marital rape is not illegal. And its trace can be seen into Indian major substantive law, which is IPC. So these verdicts are not the thought of any judge. It's not influenced by anything else, but it's only influenced by the law which is established in Indian society. So we have to see it as it is. Before understanding the provisions that what law is saying about this concept, that is marital rape, we have to find out various reports and various articles which is just studying day by day its result, its consequences into the society. We should go through it. So firstly we have to look that how many countries has criminalized it. More than 100 countries of this entire globe has criminalized the marital rape, but unfortunately India is a part of one of those 36 countries who has not criminalized it yet. NCRB, National Crime Record Bureau's report of 2019 has said that 70% of women of India is a victim of domestic violence, and sexual abuse is one of them, and it includes marital rape too. These are the reports which is stating it. Now we will move towards the provisions. What provisions are saying? So in Indian major substantive law, which is IPC, Indian Penal Code, section 375, exception number 2nd, which is saying as that sexual intercourse or sexual act by a man with his own wife, the wife not being under 15 years of age, is not rape. Meaning that if she is of 15 or below 15 and the husband is doing anything with or without her consent, it would be included into rape. But if she is above 15 and husband is brutally treating him, or other spouse is just treating him like a material to be used, in that scenario only that marital status is exempting that husband from being a culprit. Just it's a basic point we should understand about it. Now यहाँ पे क्या चीजें mainly हमें देखनी होती है, that there is certain things which is related to the presumption, and this presumption are that the wife is considered to be the part and parcel of husband life, and when she get married with that man, her identity also get dissolved with husband's identity. यहाँ भी आइडेंटिटी क्राइस आपको देखने को मिलेगी. दैट मैरिटल रेप इज कंप्लीटली बेस्ड ऑन डॉक्ट्रिन ऑफ कोवर्चर, and this is the identity crisis we can see in this present scenario also. Now we see that there is a constant concept of implied consent, that if husband and wife is into legally wedded relationship, then there is implied concept that her consent or his consent to be in a physical relationship is always for granted. It has been considered that it's always for granted. Though now it's upon you people to decide that whether in this modern era it should be criminalized or not. Because if we will study it in deep, we will find that somehow marital rape is just violating Article 21, Article 14, human right concepts, right to privacy is being violated somehow how or other. Why it is violating the very concept of preamble, that is equality, on this basis that it has just classified women into two classes, that is one wedded or unmarried. And if a woman is wedded with a man, then it's presumed that she would be forced to have a physical relationship with that spouse, and this is not with the unmarried women. So there is a not reasonable classification. So equality is being violated here. Article 21, right to have dignified life, right to have liberty, right to have sanctity of a female, it's also under 21. Right to have privacy is also under 21. It's also being violated because right to choose is their right. It's her human right to decide that whether she is into mood or she is in mind with mind to be in a certain relationship or not. So we can have various judgments of Supreme Court, which is state of Karnataka versus Krishnayappa. This was a very leading judgment in which Supreme Court had said that, I am just quoting word by word, that sexual violence, apart from being a dehumanizing act, is an unlawful intrusion of the right to privacy, sanctity of a female. In same judgment, it was held that non-consensual sexual intercourse amounts to physical and sexual violence to that female. Or in fact, it could be with the men also, not restricted to female. And while considering it, we should not forget the very concept of privacy which came into a open platform, and that was with the case Puttaswamy versus Union of India, which was a milestone in Indian judiciary to consider that yes, everybody has right to privacy, whether they are male, they are female, or they are LGBTs, or they are other. Everybody has. So we should consider it also. In Suchita Srivastana versus Chandigarh administration, Supreme Court equated the right to make choice related to sexual activity with right to personal liberty, privacy, dignity and bodily integrity under Article 21 of Indian Constitution. In 2013, UN Committee on Elimination of Discrimination Against Women, that is called as CEDAW, recommended Indian government to criminalize marital rape and to eliminate those things which is just restricting the judiciary to held anybody culprit of marital rape. And also J.S. Verma committee, which was set up after that very aggressive protest which was of 2016 related to Nirbhaya case. This committee has also recommended the same, and it has said that removing this law, women will be safer from abusive spouse, can receive the help needed to recover from marital rape, and can save themselves from domestic violence and sexual abuse. Conclusively, I would like to say that this is need of time. This is to be changed, this is to be modified. Now it's upon legislature, because modern jurisprudence is also concerned about the very protection of women, because the concept of patriarchal society is somehow getting erased day by day. So to come into a front row, we have to take a step to decriminalize it. Once Menka Gandhi had said that we can't put a camera into rooms. We can't put always spy into room, because it would be the violation of right to privacy. So when it's consent, when the consent of wife has been given to the husband while having physical relation or not, it's upon her. So decide her that what she want, and it is not that much capable to be criminalized in Indian society, because we are having certain things which is entirely different from West too. But in spite of having such things, we have to consider it to decriminalize it. Therefore, it's high time that legislature should be cognizance, should take it cognizance of this legal infirmity and bring marital rape within the purview of the rape laws by eliminating section 375 exception 2 of IPC. Thank you very much. We will meet in next video. Now you think that what should be done or not, and please give your opinion, which is highly required for this society. Thank you.